Welcome, everybody. This is BJ Hansen of the Financial and Security Products Association. Welcome to today's webinar. We're here for forgiveness and reopening your business, the next steps for dealers and resellers. Before we get started, I do the housekeeping, so I wanted to let you know that you will be muted during this program. It's keeping the audio clear. We are recording this webinar, so we want to have a nice clean copy for when you want to come back and review it. We do encourage questions and comments. I ask that you use the question box on your webcast viewer, and we will be monitoring those during the presentation, and at the end we will do the Q&A, and we will stay till we are finished with all the questions. So we're set for an hour, but we'll stay till we're all done. The webinar will be uploaded to the FSPA website. I'll have that done by Monday. And Jim has said he'll send me over the copy of the slides. So all of you that are attending, you won't need to request the slides. I will send them to you in the next 24 hours. So with the housekeeping done, I'd like to turn the presentation over to Jim Kahrs.
Well, thank you, BJ, and thank you, folks, for here. It was obviously very disappointing to not be there in person live with you guys out in Lexington for the meeting, but understandable with what's going on here. An awful lot to talk about, so let me just jump into the agenda. As far as what we're going to cover today, I'm going to do a quick round of introductions. Again, I know a lot of you folks already. I've got a co-presenter here that I'm going to be introducing by the name of Bob Goldberg, and I'll get into that in a minute. Bob's going to talk about the process of reopening and what you really need to consider as states start to ease the restrictions and businesses start to get more in gear and moving around again. Then I'm going to talk about the loan forgiveness, and as BJ said, after that we're going to get into the Q&A, and we'll stay on the line till we get all the questions that you guys have answered. Our presenters again today, you guys know me, so I'm not going to do a whole lot of introduction on myself, but I'm very pleased to have Bob Goldberg join me here. I've had the pleasure of being able to work with Bob for probably about 20 years, though he's got a few more years, 1 or 2 more years of industry experience beyond that. Bob works with a bunch of different trade associations similar to FSPA, and has been really just an indispensable resource of information. As an attorney, Bob has a very, very good understanding of how the dealer and reseller model operates, how you folks interact with your employees, with your vendors, with your customers, and really has a very, very good ability to point you in the right direction as to what you should be considering and why and how. So I'm going to turn it over here to Bob to go through the information on the reopening process. And Bob, again, thanks very much for joining us here. I'm looking forward to it.
Thank you, Jim. My pleasure, and I really cherish this opportunity to speak with the Financial and Security Products Association. It was a very kind introduction. My mom would be very proud. Thank you so much. I do want to share with you thoughts about reopening your business with the clear understanding that you're really not reopening. Most of you are essential businesses in that you provide services to essential businesses and have been opened hopefully during this period since the pandemic was announced by the White House on March 13th. But you are now going to start the process of bringing people back into your business location. You're going to start having visitors come to see you, and you're going to be expanding your services. So let's look at these things and what needs to be done, because there are a ton of legal requirements that you need to be conscious of. This webinar isn't designed to make you lawyers or make you knowledgeable of each and every one of these specific requirements, but alert you to where the landmines exist. So if you see one of these things, you are uncertain, you can call upon Jim or myself, and we can help you through these situations. So let's get started. The whole purpose of reopening and the coronavirus COVID-19 regulations was safety. Number one was safety of workers, customers, and visitors. Now, the same purpose was to assure that employees could be retained, and we'll talk about that. But when we're talking about reopening, let us focus on that safety of our workers, of our customers, and anyone coming to visit our demo room if you have one, or coming to visit our business for any purpose. Now, in the reopening process, it is essential that you have at least one appointed person who is the key person to whom all of your employees would go to with questions or concerns or procedures to follow. The difficulty will exist if you have multiple people answering questions, that inconsistency can develop. And inconsistency among workers is something that the government prohibits and something that you must avoid. So let's appoint a single person. If you're a large organization, there may be more than one person, but one or two people who are the authorities and establish the policies and procedures for reopening and for employees to follow when coming back to work from remote locations or maintaining their remote working environment. Now, you need to be concerned with the applicable regulations. And as I said, there are many of those. I, for one, I'm a suburb outside of Chicago, Illinois. I am regulated by the federal government for certain requirements, by the state of Illinois for certain requirements, by the county of Cook for certain requirements, and the village I live in. If I was in Chicago, it would be even more complex. I, who have practiced law after 40 years, have taken up that great game of golf. I'm lucky in the village I live in, golf courses are open. In the city of Chicago, they're not. So the point being that you have to look at the most restrictive things that are in place. Now, we started this process with the government, federal government, saying on March 13th that we had a national emergency. They issued guidelines. They did not issue a shelter-in-place order, which they could have done for the entire United States. As you know, the government has said those decisions are up to the states and localities. We then had the Family First Coronavirus Act that was passed, which extended the Family Leave Act to companies with less than 50 employees. Now, you can look for an exemption under that if you're less than 50, but that act extended family leave and gave the opportunity for people who had to self-isolate, care for somebody, a child or a parent or a close relative, to take family leave and get compensated by the federal government at 1 of 2 levels, 500 or 200, depending whom you were taking care of, and be able to, you as an employer, get reimbursement in the form of tax credits from the federal government. There was also the Paid Sick Leave Act, which was imposed, and that gave up to 10 days of paid sick leave for people, again, by, you would pay it, but be reimbursed. But those are just the first two. We're going to talk about the CARES Act and the financial abilities there, but there are also CDC, the Center for Disease Control guidelines. There's OSHA guidelines for your business, and there's EEOC guidelines that you need to follow. I like to say it's like taking a sip of water on a hot day out of a fire hydrant. You got more than you can take, and it's difficult to do. But let's start looking into these things. The sanitation and cleanliness rules primarily come through OSHA and the CDC. OSHA says that you're required as an employer to have a work environment that's safe and free from risk. So you will need to impose certain things on your business and look at certain things to assure your employees, if they come back, it's a safe environment. So we're going to talk about cleaning and disinfecting your business. You should have hand sanitizers. Hopefully you can find them. Hopefully you can find the personal protection equipment you need. Reconsider if you have a kitchen or lounge, if you're going to make those available to your employees. At our law firm, when I walk in there, we have about 75, 80 employees. In the morning, that lounge and those coffee machines are high maintenance and high use equipment. Can you continue that? Are you going to wipe them down after every use? What are you going to do? You may have to close your kitchen. You may have to limit it to how many people can go in, and the same for the lounge. look at your physical office layout and see if you can maintain social distancing. Some of the people we are working with, those employees that had private offices were brought into the private offices, told to close their door, but they were asked to come back to the location. If you have an open work environment, is it necessary to put up shields or space people 6 feet apart? What is going to be the most effective way to make a safe environment as OSHA requires? Look at the bathrooms. If you have 3 sinks in a row, do you eliminate the middle one? Same with stalls. You may want to do that because social distancing is important to maintain the flattening of the curve as well as preventing the spread of the virus. The OSHA requirements, they're pretty standard. They're not something that would take you by surprise. Oh my God, I have to do that. But they are things to look at. And if in fact one of your employees is to get coronavirus at your work environment, and if you fail to take these things, your liability may extend beyond what now is typically being forecast as a workers' compensation claim. Here in Illinois, there's a presumption that a worker who's at their work environment who gets coronavirus did so at their work environment. It's being challenged. Yeah, there's too many lawyers, but challenged as to whether or not that's fair. But they're looking, at least in terms of opportunities for reimbursement and coverage for employees. You're going to need to look at your employee work rules as well. These have changed. We're in a different environment, as we all know. Personal cleanliness can be imposed. My suggestion is that you make available to your employees masks, gloves, hand sanitizer, and other personal protection equipment. I will tell you that in terms of masks, we have the N95 mask and we have the surgical mask, cloth mask. You can get anything available. That if you require people to wear masks, it's a different standard under OSHA, and there's different standards that you must meet in order to require people to do it. If you make it voluntarily, it's much more easily imposed. Then people can either take it or not take it, and you don't have to do physical medical exams and other things to see if it's proper. So I would make all those things available, especially your technicians that are going out and performing service calls. Give them latex gloves, give them sanitizers, give them masks. Check with the environment they're going into to make sure that the customer has wiped down the machine. See if the service can be done after hours as opposed during business hours. There are a lot of things that you need to do both on your end and the customer's end in those circumstances. We all know now we should be sneezing and coughing into your elbow. That's a hard habit to take on after a lot of years, but I'm learning to do that, and we should encourage it as well. Meetings, according to the guidelines, should be limited to 10 people. Take a look at your conference room. If there's 12 chairs, let's take 2 of them out of there. Let's not have meetings greater than 10 people. And always maintain your social distancing through that. Now, we all have employees that not always are anxious to join in on the requirements of the employer. If people refuse certain of these things, you can sanction them, you write them up, you can suspend them, and if it gets even worse, you can terminate. Let's move on, Jim, and look at a few of the work rules that we should be considering. When you're bringing people in, you can do it in phases. You don't need to bring all your salespeople, your admin people, your techs back at the same time. In fact, you may have found that it may be more efficient for you to have some of these people working remotely. There are situations I'm involved in where our technicians are working remotely. We're FedExing parts overnight for their calls the next day. So that they don't have to come into the office and aren't subject to the risk of coming into the office environment. So you can phase people in, and even within admin or sales or tech, you can bring in just part of those people. You don't have to bring them all in. Some companies are doing a Monday, Wednesday, Friday alternative working at the headquarters routine, that you have a certain group that come in on those days and another group that comes in on Tuesday and Thursday, and then the following week they just switch that. So, you know, look at these opportunities to be able to preserve social distancing, as well as making sure that you have that social, you know, that safe environment. Flex time is another thing to look at. Your flex time can bring people in at 8, 9, 10 and have them leave at later hours. And that too can help distance things. I'm finding the greatest difficulty that employers are having are those people in larger cities where public transportation is the means of coming into the work environment. Because public transportation is a risky area. You saw the city of New York is closing down all the subways in the evening so that they're cleaned from 1 a.m. to 5 a.m. And one dealer I worked with yesterday, and that individual has operations both in New York and LA. In New York, they've allowed their people to drive into their facility, and they're reimbursing mileage for people to do that. Whereas in Los Angeles, it wasn't even an issue. Most people drove in already. You're going to have employees who don't want to come back because they're making more money now than they were from you. How does that happen? It happens when your unemployment compensation is at a level, let's take New Jersey, which is, I think, $721 a week, plus the $600 they're getting from the federal government. So you're looking at about $1,300 a week for doing nothing. And why should I come back and work? Some people, to encourage people to come back, have basically increased compensation for a period and paid that $600 so people would come back and work, and it wouldn't be the incentive to stay home and do anything. There's absolutely no requirement to do that. I'm just pointing it out that it's an incentive that's put in. People have incentivized their employees by giving hazard pay, bonus pay, and if you have a PPP loan, as Jim will talk about, these things in that 8-week period can be a portion of your forgiveness. Travel. You cannot regulate personal travel. If one of your employees wishes to go see their grandmother, their mother, who's in a different city, then under those circumstances, they can do it. When they return, you have the ability to ask about exposure, ask if they came in contact with anyone who was positive, and those things, but you can't prohibit it. In terms of business travel, you can do that. Business travel should be limited. CDC has issued a phase 3 travel alert that says don't travel unless absolutely necessary. And you know what? I'm one of those people who were out of the office traveling, 2-3 weeks every single month. And I found now that I can get a lot done virtually, and a lot of those trips, probably, although they were nice, weren't actually essential. So use your virtual meetings to do that. On customer calls, you're at the mercy of the customer. They can prohibit you from coming into their establishment. They can require you to wear masks and do other things in order to come in. They can ask certain questions in terms of your exposure. So we're going to flip that over on when we look at that in terms of visitors coming to your establishment, but recognize that if a customer has requirements that are imposed and put in place, that those must be followed. We've talked about virtual meetings, so let's move on to employee health. What are your rights there in terms of asking your employees and checking your employees for certain signs of COVID-19? Well, you can screen for their temperature. If they have a temperature, according to CDC, above 100.4, you can send them home. That is one of the signs that someone may have a COVID-19 symptom. The dry cough, the other things that are coming. They keep extending the list. Now it's even swollen toes, loss of taste, and those things. Those can all be put into a daily questionnaire of possible symptoms that you can ask your employees. You're allowed to ask them because we have a pandemic emergency that has been declared by the federal government. So you're allowed to ask certain of these personal health issues. So you can give them a daily questionnaire if they've been exposed, anyone in their family, anything along those lines and the symptoms. And once you get that information, though, it's important that you maintain it separately as a health issue, a medical issue. It's a HIPAA protected information that must be kept separate. Just don't put it in the normal employee file, but maintain it separate. Your high-risk employees, those are people like myself, over 65 years old, who may have a health issue, one or two that come up, that you may want to maintain their remote working ability because they're in a higher risk and they are concerned about coming into the environment. That is an exception. We'll talk about that in a minute. Remember, when you are asking health questions, once you find out the answers, there's privacy and confidentiality and a need to keep it separate. Now, what if one of your employees is in fact found to be COVID positive? Do not identify that employee. You have an obligation to tell the other employees that Bob came in, strike that somebody came, an employee came in, he's been tested as positive, and you have been exposed to it. But you're not supposed to say that it was Bob. You're supposed to just indicate that an employee was tested positive. Now, we're not so naive to think that the employees won't know who it is, but by law, you can't say who it was. And if asked, was that Bob who's home now? The answer should be, I'm not allowed to share that with you. What about those people who refuse the screening? I won't answer your question. You can't take my temperature. I'm not coming in because I fear I might get COVID-19. Now, if that person is not required to self-isolate due to exposure, or if they're not caring for a family member, or if their child, because the school's closed, is home and they must take care of that, if they don't have one of those exceptions, they cannot, and they refuse screening, you can require them to take PTO, sick, or vacation. You even can terminate someone or lay them off, I'd rather use that term, if they refuse the screening without justification or an other need to stay home. You can lay them off. Having a concern about contacting COVID-19 is not sufficient to justify someone not to come in. So recognize that. Now, let's go on with our reopening to unemployed. If you're testing your people, it's like drug testing. Drug testing is not always reliable. Sometimes they're retesting. My suggestion is you use a third party to do any testing. If someone questions the results, they get a positive and they say, hey, I'm not positive, then and they're retesting, have them stay home till the results of the retesting come in. You can only refuse testing based on a health issue. You have asthma or something else in terms of have a climate that you don't want, or your doctor doesn't want you to be tested, or for religious objections. We talked about those business visitors. They're coming to your office. You can impose the same requirements that you were subject to in terms of the customers that you went to visit. Contact tracing has been a successful means of limiting the spread of COVID-19. In your business environment, in your headquarters, you can require people to download an app and use contact tracing if you like. You also, many of you maybe in your service vehicles have GPS capability that is not really contact tracing. It just basically tells you where the vehicle is at the time, but you can do it within. Australia, South Korea, Israel have been successful in limiting the spread due to contact tracing. I envision that the federal government or state governments will impose certain contact tracing. Train your people, let them know, reiterate, during this period having company meetings. Our firm today at 4 o'clock, we have every Friday, at a minimum, we get together and go through things for all 75 employees. So, do that, review policies, where you stand, where it's going. Look at your employee policies. I would guess your sick leave, your family leave, your telework working requirements, vacation leave, and reporting illness are all outdated due to the COVID-19 epidemic. Reporting illness, most of us have policies in place. If you're out 3 to 5 days, you get a doctor's note before you can come back. CDC has asked us to waive that because doctors and healthcare people are much too busy on the front lines to be writing notes for the employees. And Jim and I will talk about this further, but you need to monitor daily for official updates. Things are changing so rapidly, and some of them are very concerning. There have been changes Jim will talk about in terms of rules for the PPP, that when the law says one thing, the initial interpretation was consistent with the law, and now it's being changed. But for a real expert and a real friend of your association and someone who speaks so highly, let's turn to Jim and the payment protection forgiveness issues.
Thank you, Bob. Some great information there to help these guys get ready to kind of move to the next stage of this process. So yeah, I want to talk a little bit about the government financial subsidies, and going to focus primarily on that PPP, the Paycheck Protection Program. I am going to assume, because we're pretty far into that process, that most of you that are on the line here have probably applied for and have likely either received the monies or approval that you're going to be getting it. I know in the first round, I would say from the folks that I kept pretty close contact with, it seemed to be almost like a 50-50 split as to who got in the first round. But now in the second round, I can tell you with the folks we're working with, we've had 100% of the folks that have applied have been approved and are either got the money or in the process of getting it. So the attention now starts to turn on that program to, okay, what's the process for forgiveness? The strength, obviously, of that Paycheck Protection Program is that a portion, all or some of that money can be forgiven where you don't have to pay it back. It's being called a loan up front because that's what it is, but there will be a forgivable portion. So a couple things to really understand. One, the responsibility for the accuracy of the data that you supply falls on your shoulders per the certifications that you made at the time you applied for that Paycheck Protection Program. And it also states very clearly in the regulation, in the law itself, that the responsibility for that data and the accuracy of it is on your shoulders. It actually goes as far as saying in the interim final rule that the bank doesn't even need to verify it. They just need to review it and make sure that what the data that's been given is complete. So when it comes to forgiveness, it's important to understand the process. You will be applying for forgiveness with the lender that you went to for the loan. Now, with the Paycheck Protection Program, as you probably know, you had to go through a financial institution in order to get those monies. Unlike one of the earlier stages, and I'm going to touch on this a little bit, what was called the EIDL loan, the Economic Injury Disaster Loan, was one that you could apply directly through the SBA for. That loan has, the EIDL loan had the option of an initial advance / grant, and I've heard it referred both ways, but basically you could have gotten up to $10,000 up front if you applied for that and you checked the box that said, yes, I would like the advance. And that up to $10,000 was based on $1,000 per employee. So if you got that money, that was said it would be turned into a grant. It's important to understand that the monies that you got up front for that EIDL grant or that EIDL advance come off of the forgiveness amount of the PPP loan, because technically the PPP loan it falls under the same umbrella as that economic injury disaster loan as a subsection of the SBA's what's called a 7A loan program. So it's important to look at both aspects. Did you apply for and get the PPP? Did you apply for an EIDL loan and ask for an advance? And did you get an advance? And then that will factor into the forgiveness. But you will be applying for the forgiveness through the lending institution, the financial institution that you did your PPP application through. Now, as Bob mentioned, on all aspects of this, but I would say, mostly or more than anywhere else, the rules are changing daily in this Paycheck Protection Program. So I've got a couple of links here that I'm not going to take the time now to open them up and go through them, but I think they're important for you to have. So when you get the PDF of the files, these links will be live, so you'll be able to click on it and it will take you right to the respective sites. The first one being what's called the FAQ, or the frequently asked questions surrounding the Paycheck Protection Program. I will say that they finally, in my opinion, got their act together with this document, and that what the SBA and the Treasury have been doing is just adding to the same document as new information has come up. And I think I looked at it this morning. It hadn't been updated today. It was updated most recently on the 6th. I think we're up to question number 45 at that point. The nice thing is when they add new questions, they are footnoting the bottom of that page to say when each question was added. So you need to look at that. You need to check in regularly to see what kind of changes there have been. And then the other one here is the interim final rule. That's some additional guidance that's been written up on the law itself. Now, I'm sure many of you, or most of you, if not all of you, have not carved out the time to read through the 880 pages of the law. I can tell you, Bob and I have read through much of that. Bob has probably read it all cover to cover. I have not. I've focused on the areas that are most important to us. But there's a lot of data in there, and that's really the source. I will say before I jump on to the next slide here, be very careful. There is a tremendous amount of misinformation, and flat out wrong information out there. This was put together very quickly, and there's still a lot that's being left to interpretation. And there's folks out there giving their interpretation, but they're doing it in a way that they're presenting that this is the fact. Bob and I have both worked very hard to make sure that when we're passing anything on, if we're passing it on as fact, it's because it's coming from the bill itself, the frequently asked questions document coming from the Treasury, or the interim final rule coming directly from the Treasury and the SBA. Any other information or things that you're hearing may or may not be accurate, and be careful, because again, you're the one who's responsible for the accuracy of what you're presenting and how you present it. So when it comes to the loan forgiveness on the PPP, the forgiveness is going to be based on certain expenses that you incur in the 8 weeks following the date that you got the first disbursement of the monies. Now, in most cases, what that is it's going to be, you're getting it all at once, typically, from everything I've seen. So basically, it's going to be the day the money hit your bank account, the clock starts. So you got an 8-week window beginning on that day. And I'll go through in a minute what the exact things are that you're looking at. The other thing, just as a reminder, any advance that you took on that EIDL, the Economic Injury Disaster Loan, comes off of the forgiveness, and the purpose there is that that it's forgivable money, and they're not looking to have people double dip to get the PPP forgiveness as well as additional forgiveness on the EIDL loan. So when you start calculating it, you're going to have to take off whatever you got, if any, of an advance in that EIDL. So when we look at the forgiveness, it's going to be related to certain items. Now, the first section is payroll expenses. And the way the law is written, 75% of the forgiveness amount, the amount that gets forgiven and you don't have to pay back, has to be from payroll-related expenses. Now, payroll-related expenses include gross payroll, and that's important to note. It's gross payroll, not net. What's the top line before any withholdings or anything come out of it? Gross payroll number for your employees. You're also going to add to that any state or local payroll taxes. Most states have what they call SUTA, the state unemployment tax. There may be other, I know here in New York, we've got a few others that get tacked on top of that. But there are state or local government payroll items. If there are any, then you can add that into the payroll amount. You can also add to the payroll amount any company portion of the contributions for retirement programs, 401k, IRA, SEP programs, whatever you have. So the company portion that's paid into that would be counted on top of the payroll. Now, people ask me about the employee portion. The answer is no, and the reason is because you're using gross payroll. So it's already included in the gross payroll number. So company portion of retirement contributions, and then the last item under the payroll is health insurance expenses. So the premiums that you pay for health insurance can be added to the payroll portion to calculate that 75% or more being payroll related expenses going towards forgiveness. Now there is one caveat, the same on the front end of this. When you applied for the loan, there was a cap that you could only include up to $100,000 annually of compensation for any single employee. So if you had an employee whose earnings were more than 100,000, you could only count 100,000 towards the loan amount. Well, the same thing happens on the forgiveness side. If anybody is being paid at a rate that's more than 100,000 annually, that portion has to come off of the amount that goes in for forgiveness as a payroll related expense. However, it is very clear, by the way, in the documents that that 100,000 threshold is for the payroll only. You can still add to that the retirement and the health insurance. So that could take a single employee up above the 100,000 threshold. Now, there's some additional things that can be used here towards the forgiveness amount, and that is rent. So it's rent for your facility, and you know there needs to be a lease in place for that. I know a lot of folks own their own facility, and you know they have it, you know, in a separate corporation, and that corporation is leasing the facility. Many of the folks that do that haven't taken the time to put a formal lease in place. I'm going to suggest that you should write up a lease that's backdated to the time that this relationship was in place, so that you have the documentation. But rent during that 8-week period is something that can be counted. Utilities, and utilities have been defined in the law as electric, gas, water, telephone, internet, and then this very ambiguous one that they call simply transportation. Bob and I have both been doing some digging on this to try to find out exactly what that means, and there is no specific definition to it. I'm expecting we'll get guidance here in the future. But you know with certainty you've got electric, gas, water, telephone, and internet are expenses that could be included in there. And then the other item that you can include is mortgage interest. So if you have a mortgage for real estate, the interest payments that you make during that period, that 8-week period, can also be added to the expenses. But again, when you look at the 75-25 split, only 25% of the forgiveness amount can come from rent, utilities, and mortgage interest. Now, there's a couple other things that we need to be aware of here in the forgiveness. One of them is that the forgiveness amount may be reduced based on changes in your headcount or payroll amounts per employee. And again, I'm going to say I think we're going to see more guidance coming out on some of this. But basically, you need to be at 75% or more of your full-time equivalent headcount, as compared, and you have an option here. The law gives you the ability to either compare your 8-week headcount to your headcount between February 15th and June 30th of 2019, or at your choice, January 1 through February 29, 2020. So the idea there is when you're doing a comparison, you could compare it to last year or to the first 2 months of this year, whichever you choose, and obviously that's going to be what's more favorable to you. The same thing with the payroll dollars. And again, there's some ambiguity here in that the payroll dollars, it does state in the law that it's payroll per employee, though I don't know how it's going to be interpreted. But the idea here is that if your headcount, your full-time equivalent, so if you've got part-time employees, you have an employee that works 20 hours instead of 40, they count as a half of an employee in the full-time equivalent. So your headcount needs to be maintained at least at 75% or more from what it was, and so does your payroll amount. Has to be at least 75% or more. And if it is, you don't have any potential reduction to the forgiveness based on those criteria. Now, there's another thing that's placed in here, and it says the reductions in this section may be waived if headcount and pay levels are restored by June 30th. Again, I expect there's going to probably be some more guidance coming on that, but this is part of what we have to look at. And what's really important is that we've got to have a process, and this is something I think is critical for for every one of you is you got to start looking at and modeling out what is this going to look like. And we've been doing that, now with our clients, as they're getting their loans, and basically taking that 8-week window and starting to plug in our projections of what do we think payroll is going to be and all the payroll related expenses. What is rent going to look like? What are utilities going to look like? What are our headcounts going to look like? What's our payroll dollars compared to the previous year or the first 2 months of this year, to get an idea of where is this going to come in and what kind of forgiveness can I expect? And I'll tell you that one thing that I'm seeing is that in many of these cases, the forgiveness amount is not coming up to the full amount of the loan. And the reason for it, if you think just in very broad strokes, the loan amount was based on 2.5 times your average monthly payroll. But yet we've got an 8-week window that we're looking for the expenses. So we're going from 2.5 months to 2 months. And what's happening in a lot of cases is that rent, utilities, and mortgage interest, if there is any, are not making up as much as a half a month worth of payroll. So there have been some shortfalls. And then if you add to that, if any employees were furloughed or anything like that, the payroll comes down a little further, where 100% forgiveness of the loan is seeming to be a pretty tough target to hit. So there's some strategizing that has to be done, and it starts with putting a model together to know what you can expect. And then from there, determining, when do I bring people back? How many do I bring back? Do I bring everybody back? Do I add? Some folks have said, I'm going to hire additional employees now. And if they're going to hire additional employees, how does that factor in? So you need to model it. And then the other thing is you need to start now making sure that you've got a plan in place that documents everything that all of these related expenses. Because again, the burden is going to be on you to supply the documentation to the bank in your application for forgiveness. And the law does actually outline specifically some of the key documents that you're going to need to have. And those are going to be things like payroll reports, payroll tax returns, canceled checks. So you're going to want to have everything documented. I would suggest you want a copy of at least the first page or two of your facility lease that shows the amount, that shows the date that the lease was started, being prior to February 15th, and that shows the monthly rent amount. I would suggest you probably want copies of your utility bills if you're counting them. You're going to want copies of canceled checks, your rent checks, and have everything put together. What I'm doing with our clients is we're actually going to be, for every one of them, building a binder of data that we're going to bring to the bank and hand to the bank. That's going to have everything they need, including a summary page that outlines what we're applying for from a forgiveness standpoint, and all of the copies of all the documentation that they're going to have, that they're going to need to basically, I guess, have in their files, or at least review. And understand, again, we're going to the bank for the forgiveness decision, right? They don't have to audit or verify the data in most cases, and I'll tell you one exception here in a minute. They don't have to verify or audit the data. They just have to make sure that they review it and that it's appropriate and that it's complete. And then they're not on the hook. They can't be held liable if there's something wrong. If there's something wrong, that liability comes back to you as the applicant and the borrower under that Paycheck Protection Program. Now, the one exception, as far as what they've said so far on the audits, is any loan that's in excess of $2 million, so a greater loan amount than $2 million, will be audited by the SBA. But they also had some pretty ambiguous language in there that they reserve the right to review any others. So I think we want to keep this above board, not play any games with it, and know that you're on the hook. Bob and I were talking yesterday about a situation with a company that has pretty substantial cash assets on hand, and are concerned that there might be a question that does the economic uncertainty make it necessary for them to get this loan, excuse me, to continue ongoing operations. That's the language that you are certifying, that the economic uncertainty makes the funds necessary to support ongoing operations. So have that in mind, that just and make sure that everything that you do, you document, and that you're able to prove it. And again, I would be careful with, I've had questions like, if I owe back rent, can I count 3 or 4 months worth of back rent in this time period. There's nothing specifically that says that. My belief would be no, that you didn't really incur that expense, and the law does talk about incurred and paid, but you didn't incur that expense. So I think it would be, if it was ever looked at, they'd say no, that probably doesn't work. Or if I had people say, can I prepay a few months of rent? Again, I would say that probably doesn't work, though it's nothing specifically that says not, but upon review, is a good chance someone's going to look at that and say, wait a minute, that's not accurate, or that's not appropriate for what the program was designed to do. So there's an awful lot of data here. I tried to give you, on my end, a high-level view. I know Bob did the same, focused around the reopening. But in doing these before, we found the best thing to do is, take questions from the group, because there tend to be some very good and pointed questions. So I do, as you see, have our contact information up on the screen. Feel free to reach out to us at any point. But BJ, let me turn it back over to you to give us any of the questions that have come in, and again, we'll stay on as long as we need to take those up, or if we have so many that we get to the point that we're running into a time crunch, we'll follow up if need be.
Jim, let me make a couple of BJ. Let me make a couple of points. Great job, Jim. You really did. This may help us with certain questions in terms of your payroll computation. If you offer a job to an employee to come back and they refuse, document it, and that won't count against you. So in terms of your head count and your payroll, an employee who is offered the job at the same terms and conditions and doesn't come back won't count against you. The second thing is, you don't have to have the same people in your head count. If you hire different people, it's a numerical comparison. It's not an employee comparison. And finally, there's no prepayment penalty on your loan. Go ahead, BJ.
Okay. The first question I have is, I would assume we have union employees, that those extra expenses would be covered?
Well, when you say it's going to be their payroll. So if there are extra expenses in their payroll because of overtime or anything like that, then my belief is that, yeah, that would be covered, because it is truly payroll. I know, Bob, you've talked about in other situations where folks have, they've increased people's payroll and they call it hazard pay, or things like that. So
perhaps they're discussing union dues. And union dues would be taken off of gross, so gross payroll is what we're looking at.
Okay, so for Craig, if you have other questions, please put them in the question box in your webcast viewer, and we'll come back around if you have want additional information. Okay, the next question is, can we count cell phone expenses under utilities?
Yes.
Yep, yeah, that's telephone.
All right, and what if you work out of your home? How would you apply a mortgage or that part of your expenses?
That's a tough one, because I think that it has to be that the law states that you can claim rent if you had an existing lease in place prior to February 15, 2020. So if you don't have, a lease for that, I think it might be difficult to, pass any test that it might be subjected to. If you have been paying yourself rent on a regular basis for that in the past, and you can establish that it was part of your expenses prior, then I would say, you draft a lease that you're leasing that space. But I guess I'd be a little concerned that if that was looked at more closely, it might be a difficult one to really back up and substantiate.
There may be another approach to that, Jim. How about if you're taking a portion of your home as a tax deduction on your personal tax return? So if you say that 5% of your home is for business purposes, I think you've established at least that you have, set aside a portion of that home for that purpose, and perhaps you can work with those numbers to come up with something. I agree, it's a gray area, but if you have either the lease, as Jim suggested, or you have a tax return that indicates a portion of your home dedicated to business purposes, I'd put it in. It's not fraudulent, and I think you have a basis to back it up if necessary.
Yeah, and that's a good point just from an overall, strategic standpoint, is that, if there are things that you're in doubt on, I would, again, have that test. Is there a chance that you think it might be fraudulent? If you think it's not, but you're not certain, my opinion is, if you're uncertain, then put the expense in, pay the expense. So because you're going to have proof of payment. So put whatever expense it might be, put it in, pay it. And then, the worst case, if later there's a rule that comes out that says it's not allowed, then you don't include it in your application for forgiveness. But I think the problem some folks are going to run into, and why I think the modeling is so important, is if you wait until the end of the 8 weeks and then say, oh gosh, I should have done this or I should have done that, and then you write a whole bunch of checks the day before the 8-week period ends, I think you're shining a light on the fact that it wasn't really part of the business model. Yet if there are things that you're not sure about, like I've had some folks, say, they made some compensation changes to an owner, and I said, is that going to be counted? And I said, I don't know if it'll be counted. I don't know if there'll be rules that say, you can't increase shareholder compensation during the 8-week period. But we haven't had direction now that says, no, if you want to try it, I would say do it. And the worst case scenario is it's not counted.
Okay. Yeah, the person asked that says he's going to get with his CPA to confirm it further.
Okay,
so then the next question I have is, we know we can account for the health insurance, but what about dental and vision paid by the employer?
Again, I think it's somewhat ambiguous. I would count those in. To me, that's part of your health insurance coverage.
I agree.
I'm just while we're doing this, I'm pulling out a copy of the law here. Just double check the exact language that's in it.
The next one is, does the amount the employees contribute to their health insurance premium need to be deducted from what you're including in your health insurance in the calculations?
The way that it's written right now, my response is no. However, I would not be surprised to see that change in the coming weeks, which is, again, why we've got to monitor these documents for any changes or updates or further guidance. It's one of the things that is noted very clearly in the law itself, as well as in the interim final rule. There's language at the end of the forgiveness section that says the SBA will provide additional guidance in the future.
Okay. I did not hear FICA mentioned. Is the employee's contribution, employer's contribution added in?
No, that one actually is very specifically mentioned, that all federal taxes, so that's inclusive of FICA and Medicare, are not part of the calculation. Now, the employee portion is included because you're using gross payroll numbers, but the employer portion that's paid is not something that you can add to these expenses.
Okay.
And one other thing too, just from a tax standpoint, one other quick thing on a tax standpoint too that I didn't mention that I probably should have, is that the forgiveness amount of this loan per the law is tax exempt or tax free. You as your organization, or you individually, if you're like an S Corp or an LLC that's a pass-through organization, those monies will not be taxable. That's a pretty substantial windfall, I would say, when you think about it. Any other income that comes into the organization would be taxable. If you had a loan on your books and you didn't have to repay that loan, by law, you have to then take that liability and recapture it as revenue, and that revenue becomes taxable. This amount specifically will not be taxable. And because of that, just from a mechanical standpoint, I would suggest, if you haven't already, I would set up a separate GL account under other income in my company that specifically says, PPP loan proceeds. And I would make sure that when the 8-week period is done, that the forgiveness amount is posted to that specific income account so that your accountant can clearly identify it later when you're doing your 2020 taxes and make sure that that's removed from your taxable income.
Okay, if we pay rent to an LLC with the same ownership as our company, can the rent be part of the forgivable amount?
Yes. That's an easy one.
Okay.
Yeah.
Okay.
The only suggestion, though, is if you don't have a formal lease, I would make sure you draft one and that it has to be prior to February 15, 2020.
All right.
Bob, did you have
Does
a comment on that one,
disability
too?
insurance, oh,
I agree. It's the payment, not the recipient, that counts.
okay. Does disability insurance count for forgiveness?
It states clearly that it's local and state taxes. So my interpretation is that the answer to that is no, because it's not a tax, it's an insurance. It is certainly payroll related, so I don't know if there'll be additional guidance as to whether or not that can be included or not. But as of right now, my answer on that would be no. I don't know, Bob, do you have any different thought on that?
It hasn't been established, Jim. Disability insurance, long-term, short-term, those things they have not commented on that yet.
Okay, and here's the question about, some of the monthly bills that will qualify don't necessarily fall into, clean little 8-week period. The billing cycle might be off by a couple of weeks. So you're saying that we would have to do an analysis on those bills for that 8-week period and try to allocate the cost?
What I would suggest first is, again, modeling this out. If you're talking, it depends which bills they are, but most bill cycles are monthly. And when we talk about an 8-week period, in most cases, odds are you're going to catch 2 months, of those payments one way or another. There may be some exceptions, and I think if there is an exception where something just is falling outside the parameters, we've talked about this one in other meetings that Bob and I have done, that the standard of applying when it's paid versus when it's incurred seems to imply that you could do an accrual basis if you needed to. But I would start with modeling it and know that if there is an issue, where and what is that issue? And if need be, then I would probably be submitting based on an accrual basis of that 8-week period, not necessarily exactly when the payment was made.
Okay. Does anybody else have any questions? I don't see anything else coming in, and I've covered everything in the question viewer. So based on that, again, you have Bob and Jim's contact information up on the screen. I will be sending the slides out, so you'll have that. We'll get those out to you within the next 24 hours. This webinar is recorded, and it will be posted up on the FSPA website for Monday morning. And again, thank you to Jim and Bob for this incredible amount of information and the help that you've given us today. And thank you so much to all the FSPA members that are on board. Thank you. This was an incredible benefit to the members. And I know I'll say thank you on behalf of everyone. And have everybody have a great rest of your day and stay safe and stay well. Thank you, everyone.
Thank you, BJ.